The doctrine of separation of powers is an important topic in administrative law. Before we discuss the separation of powers, let us look at its opposite, that is, the concentration of power. In ancient times, the king was the law, because the king decided what was the law, enforced the law as per his will, and also settled any disputes. At the same time, the king himself was above the law, because the king was not accountable to anyone for his own actions. And if any subject was aggrieved by the king or the state's actions, there was no recourse. They could not appeal to anyone else. Deciding the law is legislative powers, enforcing the law is executive powers, and settling any disputes is judicial powers. If all these powers are concentrated with one person or with one body, then that person or that body will become completely unquestionable and all powerful. And that is not an ideal situation. Because there should be some control, there should be some checks and balances, even on the state's powers. So, separation of powers is common sense. Even though the separation of powers may be common sense, it was not formally written down as a doctrine or as a principle till Charles Montesquieu came along. He was a French judge, a philosopher, and an author who wrote a book called The Spirit of Laws in 1748. In that book, he proposed the concept of Trias Politica, which is the idea that the power of the state should be strictly separated into three branches: the legislature, the executive, and the judiciary. Montesquieu's book and his philosophy of strict separation of powers considerably influenced the founding fathers of the United States, who included this doctrine when they drafted the American Constitution. After independence, when the Indian Constitution was being drafted, this concept of strict separation of the three branches of the government was considered. In fact, in a Constituent Assembly debate in December 1948, Professor K.T. Shaw tabled a motion for the insertion of a specific article 40A into the Constitution, which would mandate the complete separation of the three organs of the state, just like how the separation had been mandated in the American Constitution. There was some support, there was some opposition, and finally, when Sri Ambedkar was called upon to speak on this motion, he said that this matter had been debated previously. And there was no dispute that the executive should be separated from the judiciary. However, while the rigid separation of the executive from the legislature was included in the American Constitution, it had been criticized by many Americans themselves, who were quite dissatisfied with how such a separation was working, which meant that this model was not ideal and should not be followed in India. Subsequently, the motion was not passed and the Indian Constitution does not have a strict separation of powers. In India, the three branches of the government have their own core functions. There are also some areas where there is an overlap, where one branch seems to be doing the work that should ideally be done by another branch. For example, the legislative may perform certain functions that seem to be judicial in nature, like the impeachment of the president or the impeachment of the judges of the high courts or the Supreme Court. The legislature can also investigate, adjudicate, and remove certain constitutional authorities, like the Comptroller and Auditor General of India or the Chief Election Commissioner. The Parliament has also the power to adjudicate and punish its own members for breach of parliamentary privileges or contempt of the House. So such functions are similar to judicial functions. Coming to the executive, the ordinance making powers of the president and the state governors are the powers to make laws, which is normally done by the legislature. The executive, represented by the Council of Ministers, plays a key role in the drafting and the introduction of legislative proposals, and also in the recommendation and assent to bills. The executive also performs some quasi-judicial functions, like the work that is done by the regulatory bodies or the tribunals, which seem to work like the courts. And the judiciary performs some functions which seem to be legislative or executive in nature. The courts can lay down some rules or mandate some guidelines which function like the law. For example, in 1997, the Supreme Court issued the Vishaka Guidelines against sexual harassment in the workplace, which were in use till 2013, till the POSH Act was passed. Even the midday meal scheme and the provision of free and compulsory education were originally mandated by the courts. These actions of the courts are legislative in nature. The courts can and have directed certain executive actions also in the interest of justice or in public interest. For example, the Supreme Court ordered the executive to perform some specific steps to protect the Taj Mahal in the Taj trapezium case. These actions of the court are executive in nature. In some landmark cases, the Supreme Court held that this overlap, where one branch seems to be performing the work of another branch, which seems to conflict with the doctrine of separation of powers, is valid, as long as the essential legislative function is not delegated entirely and is retained by the legislature. And for any such overlaps, there are adequate procedural safeguards. There is fairness and the possibility of judicial review. And the judiciary retains the ultimate oversight to ensure that such delegated powers are not misused. And even where there is a clear separation of powers between the three branches, the Constitution has a system of checks and balances so that there is an oversight on each branch by the other branches. For example, the Parliament can remove the government, which is the executive, through a vote of no confidence. Budget approval gives the legislature the control over the executive's expenditure and financial policies. Parliamentary committees can question ministers about their administrative decisions. The Parliament also has the power to impeach the President. The President is from the executive and the judges from the judiciary under certain situations. And standing committees can review and recommend changes to proposed legislation. Similarly, the executive has some oversight and some checks and balances against the legislative. The executive can promulgate ordinances when the Parliament is not in session. And these ordinances are nothing but temporary legislation. If the President does not agree with some proposed legislation, he can return those bills to the Parliament for reconsideration. In this way, he can influence the legislature. The President has the power to dissolve the Lok Sabha and call for fresh elections. The Council of Ministers, who are a part of the executive, can recommend President's rule in states during constitutional breakdown. It is the executive which controls the drafting of the most significant legislative proposals, which later become statutes after being passed by the legislature. This way, the executive has a say in the legislation as well. Coming to the judiciary, there are many cases where the courts have declared certain laws as being unconstitutional. Courts can issue writs to protect fundamental rights against executive actions. The Supreme Court can review constitutional amendments for basic structure violations. Courts can and have struck down executive orders that violate constitutional principles. And public interest litigation allows citizens to challenge any government actions through judicial intervention. And finally, let us look at some important case decisions regarding the separation of powers. In the Ram Javaya versus State of Punjab decision, the Supreme Court acknowledged that the Indian Constitution does not strictly adhere to the separation of powers as a rigid doctrine. However, one organ of the government should not encroach upon the powers of another arbitrarily. In the Kesavananda Bharati case, where the court laid down the basic structure doctrine, the court essentially held that there are some limits to the powers of the legislature. In the Indira Gandhi versus Rajnarayan case, the court reaffirmed the separation of powers. Even if this is not specifically stated in the Constitution, it is implied. And any constitutional amendment that attempted to place the election of the Prime Minister beyond judicial scrutiny is not valid, because that would go against the concept of checks and balances. In the L. Chandrakumar case, the court held that the quasi-judicial functions of the administrative tribunals are necessary and valid, but the actions and the decisions of the tribunals and other administrative bodies will still be subject to judicial oversight. The tribunals cannot just take over the judicial functions in their areas completely. And in the Union of India versus R. Gandhi case, the court looked at the composition and the functioning of the NCLT and the NCLAT, ensuring that the separation of judicial power from the executive is maintained by having persons with judicial experience preside over such forums, so that they have the experience and the expertise required to conduct such judicial process effectively.